expertise and role under the Refugee Convention. If the executive is now asking Parliament to become complicit in overturning findings of fact by our Supreme Court, this made explicit by the Noble Viscount Hailsham's Amendments 3 and 4, it should at the very least, my lords, allow Parliament to hear advice from the expert body that the Supreme Court found so authoritative before allowing facts to be deemed as having changed. Accordingly, my lords, Amendment 5 replaces the edict that Rwanda is safe with the belief that it may become so, because it should be our unanimous aspiration that the whole world becomes a safer place for persecuted and displaced people. Further, my lords, as even an independent expert body should never usurp the fact-finding jurisdiction of our courts, especially in dangerous and fast-changing times, Amendment 34 makes clear that even clear and positive advice from the UNHCR would create only a rebuttable presumption that Rwanda is safe, in keeping with earlier legislation as observed by the Constitution Committee of your Lordship's House. It would not hobble our courts with an absolute conclusion. Yet, my lords, if the government is really so confident that the Rwanda Treaty, unlike the Refugee Convention so long before it, will be implemented so as convincingly to render that country safe, the government has nothing to fear from either these amendments or our courts. I beg to move.
Amendment proposed. In clause 1, page 1, line 2, after the, insert the word first. The question is that this amendment be agreed to.
I must begin by apologising for the fact that I was abroad at the time of second reading and was therefore not in my place at that time. My Lords, much was made at second reading of the notion that the bill in some way contravenes our constitutional principles, is an affront to the separation of powers, and infringes on the power of the judiciary. I think those allegations are thoroughly misconceived, but they are highly relevant to this amendment. The plain fact is that we are a parliamentary democracy. That means that Parliament is sovereign. And the reason why so many of us cherish that overarching principle is that we attach high importance to something called accountability. Accountability, my lords, was not a word which featured very large in your lordship's debate on second reading. The courts are accountable to no one. They proudly proclaim that fact. Many of the bodies to which Parliament has in recent years outsourced some of its responsibilities have little, if any, accountability. But Parliament itself, or at least the other place, the House of Commons, in which I was privileged to serve for 27 years, is truly accountable. It is answerable to the British people at regular intervals, and its members can be summarily dismissed. There are those who seem uncomfortable with our system, and it is indeed true that there has been something of a whittling away at it in recent years. The courts have extended their power, and Parliament itself has contributed to it by the outsourcing to which I've referred. I often think it's a pity that those who praise these developments fail to come up with some suggested alternatives to parliamentary democracy, but there it is. These amendments, if passed, would mark a new jump in this process. I would like to ask those who support it to address the question of accountability. To whom is the United Nations Commissioner for High Refugees accountable? Perhaps they might say to the General Assembly of the United Nations. To whom is that body accountable? Neither the High Commissioner nor the General Assembly have any responsibility for securing our borders. They have no responsibility for the safety of those who make the perilous channel crossing. They have no duty to take into account the resentment felt by so many against the sheer unfairness of illegal immigration and the way in which it gives preference not to the most deserving, but merely to those who can afford to pay the people's smugglers. Our elected government and this Parliament do bear those responsibilities, and the House of Commons is directly accountable to the electorate for the way in which those responsibilities are discharged. These amendments would prevent our government and Parliament from discharging those responsibilities. They seek to outsource those responsibilities to an unelected body with no accountability. The acceptance of these amendments would constitute nothing less than an abdication of the responsibilities of government. I note without surprise, of course I give rise to
I'm most grateful to the noble and learned Lord. I don't understand the argument he's making. As I understand the amendment in the name of the noble learned Baroness Trivati, the responsibility laid on the UN High Commissioner for Refugees would be to advise the Secretary of State. I don't see how that makes him accountable. It would remain the Secretary of State, surely, who was accountable to this Parliament for the decisions he decided to take in the light of the advice he received.
Well, I fear not. The easiest way of replying to the noble lord is to read from the members' explanatory statement of the amendment. This is what they say. The amendments require positive UNHCR advice on the safety of Rwanda to be laid before Parliament before claims for asylum in the UK may be processed in Rwanda. So if there is no positive advice from the UNHCR, those claims cannot be processed in Rwanda. I hope that aids the noble lord's understanding of what I'm saying.
I'm grateful again to the noble lord. I was referring to the text of the amendment.
Well, I think it's perfectly reasonable if one looks at one wants to know what the intention of the amendment is, to look at the member's explanatory statement of that amendment. That is indeed the purpose of the explanatory statement. Lords, I note with interest, but not with surprise, that none of these amendments are signed by any member of the opposition front bench. I'm not surprised, because no party which aspires to government could support the abdication of the responsibilities of government which these amendments would achieve. Before I sit down, I just want to say one word about Amendment 7, which is in the name of my noble friend Viscount Hailsham and others. Amendment 7 asserts that the decision of the Supreme Court was a finding of fact. But the decision of the Supreme Court was not a finding of fact. It was a finding of opinion. The Supreme Court's opinion that the removal of asylum seekers to Rwanda would expose them to the risk of refoulement. It is an opinion on which men of good faith and true can disagree. Indeed, it is an opinion on which distinguished judges disagreed. The Divisional Court, one of whose two members was a Lord Justice of Appeal, came to the conclusion that what the government was proposing to do was entirely lawful. The Court of Appeal, by a majority, disagreed, but the then Lord Chief Justice dissented. So, in my view, when the Supreme Court reaches a conclusion on a matter of opinion, it is entirely legitimate and entirely proper constitutionally for Parliament, democratically accountable to the House, to the people, as the House of Commons is, and the Supreme Court is not, entirely proper for Parliament to substitute its own opinion. That is what this bill does, and that is why I support it.
My Lord, I rise to speak very briefly in support of Baroness Chakrabarty. I just want to put on record for this House that the Bar Council has a real concern about the apparent incompatibility between the European Convention for Human Rights and this bill. The Supreme Court, as we know, made a decision, in my view, on the basis of facts, that Rwanda is not a safe country. And they put a whole series of points to support that view. This bill has not in any
to consider challenges brought of an individual nature in relation to particular claimants.
My Lords, that may be so, but I think the point I've made stands, and I think perhaps I've said enough to point out that the Bar Council has very real concerns about this bill.
It is... Please.
My Lords, I will speak mainly to Amendments 11 and 12 in the name of my noble friend, Lord German. I can't stop myself saying that it really goes against the grain to do anything which suggests that Liberal Democrats regard the bill as requiring only some tweaking for it to be acceptable. But I'd like first to make a general comment about Clause 1. For many years, governments, plural, have opposed amendments setting out the general purpose of a bill on the basis of a clause having no effect and being rather confusing. And I used to find that understandable, though I signed some such amendments. They've tended to be narratives describing hopes rather than expectations or anything firmer than that. The noble Baroness Chakrabarty has commented on the changing fashion, them being there to make the courts wary of the direction in which they might like to go. But I think that this problem applies to Clause 1, and I would note that there is a notable omission from the exposition of the government's policy, and that is tackling people smuggling, abhorrent in itself, not only because of the smugglers' role in bringing asylum seekers to the UK. The Illegal Migration Act has a similar introductory clause, but specifically it says in section 1(3), accordingly, and so far as it's possible to do so, provision made by or by virtue of this Act must be read and given effect so as to achieve the purpose mentioned in subsection 1. So I believe it's important to be clear about the effect of Clause 1, the legal effect, that is. If it is intended that the clause is to be relied on, then I think it needs to be sharpened up. For instance, terminology such as the system for processing claims is to be improved, an objective of the treaty, which is a pretty low bar. But my central point is that we need to be very clear about the legal effect and status of this clause, because there'll be little point in amending the clause at report unless the amendment has an effect, either as a standalone or by subsequent reference, such as the Act not coming into force unless a provision in Clause 1 is met. This may seem a rather technical point, but looking ahead, I don't want to be tripped up on it. Amendment 12, and I'm aware it's an amendment to the clause whose effect I've been querying, is therefore a probing amendment, and it's an amendment to the definition of a safe country. It includes in 15b little 2 a determination of being treated in accordance with that country's, i.e. Rwanda's, obligations under international law, and the amendment would change that to being in accordance with the UK's obligations under international law. The treaty is predicated on Rwanda being under the same obligations and as observant of them as is the UK, so that the transfer to Rwanda, as I understand it, means really only a change of venue. Dr. Google didn't really help me yesterday in finding what conventions Rwanda has signed up to and, importantly, ratified and observed. But since we are proceeding on this on the basis that everything that we would do in this country will apply under the new regime, I'd be interested in the Minister's comments. Amendment 11 is related to this, Clause 15A, which also defines safe country for the purpose of the bill. It includes or refers to the UK's obligations that are relevant to the treatment in that country of persons who are removed there. Surely, my lords, it's all obligations relevant to treatment of persons removed there, not just in that country. So both amendments go to the issue of safety. That is the bill's compatibility with the UK's human rights obligations, and it's the UK's human rights obligations that are crucial as part of this whole regime.
It is a hard act to follow, so many lawyers here, and I hope that my compassion and conviction might help me where I'm missing in legal expertise myself. My lords, I support the amendments to Clause 1 in the name of the noble Baroness Lady Chakrabarty, which introduce an additional purpose of compliance with the rule of law and the role of the United Nations High Commissioner for Refugees. I apologise I was unable to join your lordships for second reading as I was overseas. I have read the Hansard record of the debate, during which many noble lords raised what I see as the fundamental issue at stake with this bill and the Rwanda scheme more broadly, how it is squared with the rule of law, with the international agreements and obligations which are the bedrock and defence of our freedom and prosperity. My lords, I come to this with a conviction that our best chance of solving the global challenges we face, illegal migration among them, is not through unilateral action, but through international cooperation and by standing up to the rule of law. Other noble lords have explained how these amendments would help ensure that refugees really are safe, and that the importance of this as a matter of humanity as well as of law. I suggest that recognising a role of for UNHCR is also important from an international perspective and as a route towards a lasting solution the governments seek. It is right to want to reduce people smuggling, but if this bill is to have a positive impact, it will only be as a part of a wider approach. The preamble of the 1951 Refugee Convention is surely correct when it states that a satisfactory solution to the problem of supporting refugees in a fair and humane manner without placing an undue burden on any state cannot be achieved without international cooperation, and notes that the effective coordination of measures taken to deal with this problem will depend upon the cooperation of states with the High Commissioner. As I have argued in your Lordship House before, a lack of respect for international law and the weakness of international institutions lies behind the larger number of people forcibly displaced around the world. While not the only cause, wars of aggression, indiscriminate or deliberate targeting of civilians, war crimes and crimes against humanity drive displacement. We will not reduce the number of displaced persons globally while wars and atrocities continue unchecked and while international law is applied unevenly. At a time when we and the wider West are struggling to maintain any credibility when it comes to the rule of law and international cooperation, recognizing in law a place for UNHCR is determining the safety of the Rwanda scheme would be a small step towards demonstrating our ongoing commitment to international institutions and agreements which are critical to global security. My Lords, it has become a bit of a trope to say that the Refugee Convention and UNHCR itself are outdated and unable to rise to the magnitude of the task at hand. In supporting a role for UNHCR in this legislation, I would challenge that view. It is worth putting the scale of the refugee situation in some context. As a recent book, How Migration Really Works, by Professor Hein de Haas, one of the world's leading experts on migration, sets out very clearly, current refugee numbers are not in fact exceptional or unprecedented. There are 30 million refugees globally, but this is 0.3% of the global population, only marginally above the proportion of refugees in 1992. The vast majority of displaced either stay in their country of origin or their immediate region. It is a small minority who come to Europe and to the United Kingdom. This is a challenge that we should be able to rise to. The refugee crisis is one of the protection and political will, not only sheer numbers. My Lords, this bill is all about signalling. The government hope to signal that they are tough on illegal migration and to deter small boat crossings. But we are at risk of signalling that we are uninterested in the rule of law and in our international agreements and cooperation. That would be a very serious mistake, whether for our ability to cooperate over refugees or on our other global issues and international rules-based order.
My Lords, I rise to support Amendment 1, tabled by Noble Baroness Chakrabarti, Baroness Hale of Richmond and the Most Reverend Primate, the Archbishop of Canterbury, and Amendments 2, 5 and 34, tabled by the same, to which is also added the name of the Viscount Hailsham. I also wish to offer supportive comments on Amendment 7 to Clause 1 in the bill, tabled by the Noble Lord Viscount Hailsham, the Noble Baroness Chakrabarti, and the Right Reverend Prelate, the Bishop of Manchester. The Lord Archbishop of Canterbury is present, but is unable to attend the entirety of this debate. The Lord Bishop of Manchester is unable to be with us this afternoon. My Lords, it will be a very slight augmentation to the wisdom of this House to know that we on these benches do not favour the outsourcing of asylum claims to other countries or territories. This is rather different to what the Noble Lord, Lord Howard, was saying about the outsourcing of power. We do recognise, however, that the courts have deemed this lawful in certain circumstances. The Supreme Court deemed to fall outside our own obligations under the law. I accept, my Lords, that the recent treaty between His Majesty's Government and the Republic of Rwanda makes legally binding, and with additional enhancements, the Memorandum of Understanding between the two governments of 2022. For example, the undertaking that under the new asylum procedure, there is a commitment that no person relocated under the treaty to Rwanda will be sent to any country other than the UK, if the UK so requests. However, as the House knows, the International Agreements Committee of this House does not recommend ratification until further evidence is available. Nonetheless, my Lords, there remain very significant concerns about the contents of the bill as it currently stands, not least using legislation to make a declaration of fact in order to correct a court which has heard evidence. It is clear, my Lords, that the government has gone to a great deal of effort in order to provide evidence to persuade critics of the feasibility of removal to Rwanda as a safety and properly functioning process, while at the same time trying to satisfy its policy aim and critics of a different stamp, that the limited capacity of this scheme will be a deterrent to those who make long and dangerous journeys in order to cross the Channel. The purpose of these amendments is, I believe, to match the bill more closely to the requirements of the Supreme Court judgment, and thus both more just and less open to challenge. My Lords, for the sake of the people whose lives will be affected by yet more upheaval, who as it stands will not even have the opportunity to have their claim heard in this country, we cannot afford to get this wrong. Courts and tribunals must be able to make a judgment about the safety of Rwanda based on a consideration of the facts. We are not primarily discussing the suitability of Rwanda, we are discussing its safety for people who, by definition, have highly complex lives and circumstances. The treaty introduces safeguards and checks, so it should, but these are not yet in force. I share the view, my Lords, that more is needed. The United Nations High Commissioner for Refugees, an agency with which the government has worked with in a highly effective way over many years, should provide that positive judgment of safety. Until then, the government is taking an unreasonable risk by sending anyone to Rwanda. These amendments, my Lord, offer practical steps which strike a kind of balance we are wise to pursue in this revising chamber. They do not wreck the bill, nor remove the objective of deterrence from it, though we can debate in due course the degree of inhibition it brings into the process. Rather, these amendments, my Lords, provide an adequate mechanism for addressing concerns about the UK's compliance with international law, and appropriately given the name of this bill, the safety of Rwanda as a destination for the processing for asylum claims intended originally for the UK. These amendments, my Lords, are important for the preservation of judicial oversight and for the maintenance of the separation of powers, which is a fundamental component of our Constitution. It is for Parliament to make laws, it is for the judiciary to judge cases, including the lawfulness of government decisions, and to make findings grounded on the basis of evidence. Amendment 7, my Lord, seeks to make it plain that the bill before us replaces the Supreme Court's finding of fact. My Lords, a bill cannot change the actual situation on the ground in another country. It can only mandate that evidence to the contrary. That is disregarded. We have a duty of care in international law towards asylum seekers who arrive in this country. Legislating, my Lords, that Rwanda is a safe country does not necessarily make it so for the potentially vulnerable people who might be sent there. This amendment seeks to make it plain that the bill before us today replaces the Supreme Court's finding of fact. The bill's primary purpose is to disregard the UK's own Supreme Court's finding that Rwanda is not a safe country for asylum seekers. A bill cannot change the actual situation on the ground in another country. It can only mandate that evidence to the contrary is disregarded. We have a duty of care towards asylum seekers who arrive in this country. Legislating that Rwanda is a safe country does not necessarily make it so for the potentially vulnerable people there. Let us be clear, my lords, what it is we are doing. The Law Society have said unequivocally that it is inappropriate for the government to undermine the judiciary in this way, and that the bill threatens the balance of powers in the United Kingdom. This amendment would put onto the face of the bill that a judicial finding of fact is being replaced. I hope, my lords, that we give these amendments a fair wind.
My support to the amendments in the name of the Noble Baroness Chakrabarty, the Most Reverend Primate, and the Most Noble Lady Baroness Hale. And in doing so, to express some slight puzzlement that the government seems to have difficulty in accepting these amendments. The government tells us again and again that nothing in this bill is contrary to our international obligations. Okay, well then just accept these amendments and make that even clearer than it was before. One may have one's doubts as to the reason why the government is not going to accept these amendments, because basically its position is that of the Red Queen in Alice. It's so because I say it's so. Now, I would like to address one or two of the points made by the noble and learned Lord Howard, because they were extremely far-reaching and, I would say, very, very damaging and disruptive of our ability to support a rules-based international order. Because he seemed to not take into account that it was this sovereign parliament that ratified our membership of the United Nations in 1945. And that Charter of the United Nations contains the Charter for the General Assembly, and the General Assembly appoints the High Commissioner for Refugees. So I don't think his argument about lack of accountability stands up. But also, if you think about it, in contradicting any role for the High Commission for Refugees to give advice to us about whether or not Rwanda is a safe place, is an extraordinarily far-reaching and damaging claim to make. Because if they...
It's not, as I said in answer to the Noble Lord Fair, it's not simply a question of seeking advice from the United Nations High Commissioner. The amendments clearly state that unless positive advice is obtained, no one can be removed to Rwanda. So the decision will no longer be the decision of the Secretary of State, it will be the decision of the United Nations Commissioner for Refugees. That is the point. It's not just advice, it's advice which would be binding, according to these amendments, on the government.
I thank the Noble Lord for that point, which interrupted me before I got to the answer to his question. That is fine. What I had been going to say was that the doctrine, according to the Noble Lord and learned Lord Howard, is that every member that has signed the Refugee Convention, well over 150, I think, and ratified it, including our sovereign parliament, has the right to reinterpret the convention as it wishes. Now, you only have to, for 1 minute, stop and think what that implies to realize that it implies complete chaos and the law of the jungle. If all 150 members of the United Nations Refugee Convention, 150 plus, are able to stand up and say, well, actually, this is what I think the convention means, and I don't care a damn what the High Commissioner for Refugees says, then we are living in chaos. And it's to avoid that these amendments are being put forward, and I do strongly support the arguments of the Noble Lady Baroness Hellich, who seemed to me to express extremely eloquently the reason why this country has a real interest in paying attention to these matters. Yes?
For giving way. I thought it might help the committee for me, before this debate with the Noble Lord Howard rumbles on, to clarify that he is quite right, that this amendment, as currently drafted, requires positive advice from the UNHCR, not just advice, positive or negative. Now, the reason for that, in the current iteration of the amendment, is that the Prime Minister expressly said that this bill is designed to assuage the concerns of the Supreme Court, and they were based predominantly on the negative advice from the UNHCR about the situation in Rwanda. Such was the nature of the evidence of UNHCR and the credence that our Supreme Court gave to that evidence. However, the noble Lord Howard of Lympne, or indeed the government, are welcome, if that formulation is too rich for their blood, they are welcome to amend the amendment or offer their own, which requires only advice, positive or negative, by the UNHCR before either the Secretary of State or indeed Parliament can look again at whether Rwanda has changed subsequent to the treaty and is now or in the future a safe place for asylum seekers and refugees.
I don't wish to pursue that course at all. I'm not one of the proposers of this amendment. I'm merely supporting it. But the arguments that I'm adducing are arguments that relate to the state that this country would be in if it issues forth into the world and says it has an absolute right to interpret a United Nations convention which it ratified many years ago and which it has supported through thick and thin ever since, and now wishes to contradict. And that is a serious matter, and I do not believe myself that the noble Lord Howe's arguments ought to carry weight, because I think the implications of them for our position in the world and our support for a rules-based international order would be extremely damaging.
And very friend. My Lords, I want simply to say a few words in support of Amendment 3 and 7, which are in my name, and also to express some more general support for the position adopted by the noble Baroness Chakrabarty. As in the House of Commons for many years, and I know the forces that are put in place to assure the opinion of the House of Commons, the elective dictatorship of which my father spoke. But what is absolutely certain is that it is not the opinion of this House. And we know that to be a fact because of the vote that took place on the 22nd of January in this House. In my opinion, we should not put onto the face of a bill a statement which is manifestly untrue. And hence why I have put down amendments which state the truth. And the truth is that the safety of Rwanda is the opinion of the government. That is the truth. And why on earth should we not enact that simple truth, rather than commit what in other circumstances would be described as a lie? As regards Amendment 7, we should state in clear terms what we are doing. We are, in fact, using a statutory and untrue pronouncement to reverse a recent finding by the Supreme Court. My learned friend, Lord Howard, for whom I have the greatest respect, we were colleagues for very, very years. He was in the House of Commons for 27 years. I beat him. I was there for 30 years. But he was a lot more distinguished than I was. But to try and say of the House of Law, of the Supreme Court, that they didn't make a finding of fact is to turn a situation on its head. They expressed an opinion as to fact, as juries do in criminal cases. and an opinion as to fact is a finding of fact. Now, I'd like, if I might, to take a little broader view. I happen to share the view, and I suspect it's pretty general in this House, that both legal and illegal migration is far too high and should be reduced. I share the very correct intention of the government that we need to deter illegal migration. My objection is not to the purpose, but to the means which is being advocated, which is, in my view, wrong in principle and will not succeed. However, it is clear to me, as it is clear to the Baroness Chakrabarty, that the government decides to push ahead and will doubtless, in ping-pong, reverse our amendments. But in the spirit of compromise, as did the Baroness, I would like to make some positive suggestions. Leaving aside the issue of principle, I'm concerned that the government is seeking to enact, without any proper assessment, its judgment as to whether Rwanda is safe. And that means not just whether the treaty is put into place within Rwanda, but also whether the provisions of the treaty over a period of time are implemented. And also, not just that, but also whether for other reasons we can say that Rwanda is safe. That we are entitled to do. And be clear about it, that is not a one-off assessment. That has to be a continuing assessment, because things can change. And the other thing we need to be absolutely clear about is whether the policy objective is working. We are told that the purpose of the bill is to reduce illegal migration across the Channel. That is a judgment. I don't happen to think it'll work. But one thing is certain, is that we don't know whether it will work now. But in the course of time, we may be able to form a view as to that. So my concern is that the bill provides no mechanism for a continuing assessment, both as to the safety of Rwanda and as to the success of the policy. And I believe that Parliament is entitled to demand a continuous and authoritative assessment. Now, we could argue whether it should be based on the European body, or whether, as Amendment 81 suggests, the Joint Committee of Human Rights, or as I've in the past suggested, a special joint committee, select committee appointed for the purpose. But there is a way forward, which is this. This bill does not come into operation without both houses of Parliament, by an affirmative resolution, triggering it. And they can only trigger it once a report has been received from whatever assessment monitoring board we put into place. And that is not enough, because, as I say, what we need is continuing assessment. So what I contemplate is something like this, that the initial trigger should be, say, for 2 years. It could then be renewed by another statutory process, affirmative resolution, on the basis of a further report, renewed for 2 years. And then again, if the Secretary of State thinks he'll get away with it. But that way, we will have a continuing process of assessment. And that would give this House and Parliament in general something on which it could honourably proceed. And I would like to think that my noble friends on the front bench will show a certain degree of flexibility. Because if they don't, it may be quite difficult to persuade their critics to be flexible.
I briefly want to follow my noble friend Lord Helsham in his remarks. And had he been the presider in a three-man court or three-person court, I would have been very happy to say that I've heard his speech and have nothing else to add. But since we're here, you have the disadvantage. You have the disadvantage of hearing what I have to say. like my noble friend Lord Howard of Lymm and my noble friend Lady Hellich, I regret I was not here at second reading, and I apologise, but I've read the Hansard of the debate. I'm always reluctant to disagree with my learned friend, my noble friend Lord Howard, but I think he took too narrow an approach to the questions before us. And I use clause 1(2) little b, which is the subject which my noble friend Lord Helston attacks, as a hanger on which to make a few remarks. I think, if I understood him correctly, my noble friend Lord Howard said that Parliament can essentially do what it likes. And of course, he's perfectly right. Parliament can be as foolish as it likes. Parliament can pass a law saying that all dogs are cats, but it doesn't make all dogs cats. Parliament can pass a law saying that Rwanda is a safe country, but it doesn't make it a safe country. And this is where I agree with my learned friend Lord Helston. It's for the government, it's for the executive to advance its policy, whether it's a good policy or a bad policy, but it's for the government to say it is our political opinion or it is our policy that Rwanda is a safe country to which to return or to which to send failed asylum seekers. If the government then wishes to have its view tested by Parliament, well, again, it can go ahead and do it. So what the government is proposing as a matter of policy is not a constitutional outrage, but the way in which they are writing it down in clause 1, subclause 2, little b, is, if I may respectfully say so, just plain silly. And I think it is worse to be silly than it is to be guilty of a constitutional outrage. And this is not a constitutional outrage. It's just plain silly. And ridicule, if I may say so, is a more powerful weapon than the constitutional and legal arguments of any number of lawyers. It would, of course, as the noble lady, Lady Chakrabarti, advances in one of her amendments, it would, of course, be helpful to have a UNCR opinion in favour of the safety or otherwise of Rwanda. But I have a feeling that exporting government policy to the UNCR is not a good idea. It would be helpful to have that opinion, but it's not essential. And the government must stand on its own feet, bring its policy to Parliament, have it tested, and it will either survive or not, as the case may be, on the merits of the facts. But the assessment of whether Rwanda is a safe country is an assessment that must be for the government to be considered by and to be agreed with by Parliament, but we as a bicameral parliamentary body, I suggest, are not equipped to reach those sorts of conclusions. We can agree with, we can disagree with the government, but we are not equipped, it seems to me, in a presidium to reach a conclusion about whether, as a matter of fact, the Republic of Rwanda is a safe country. My Lords, I don't wish to undermine or underplay, or shall I say, underestimate the hugely difficult political problem that the government faces with illegal immigration and the making of unsound asylum applications. Nor do I wish to undermine their genuine and very proper decision and policy to stop the boats. But if we are to stop the boats, if we are to reduce the amount of illegal immigration and the amount of bogus asylum applications, may I suggest that the government would go a long way if it had the confidence of its own convictions and allowed clause 1(2) little b to say that the Act gives effect to the politically expedient policy of the government that the Republic of Rwanda is safe, rather than trying to shift the responsibility for that opinion upon Parliament. Parliament may come to agree with it, but the initial policy is one for government, and to that extent, I wholly agree with my noble friend, Lord Helsham.
Well, thank the noble Lord. I'm another supporter of Amendment 3. Clause 1 is an example, as it seems to me, of the current vogue for starting bills not with operative provisions, but with preambular statements of the obvious, a custom which is always irritating, but normally harmless. There is, however, harm, I suggest, and not just silliness, in Clause 1(2)b, with its rather grand invocation of the judgment of Parliament that the Republic of Rwanda is a safe country. A judgment apparently for all time that there is no provision to revisit or to change. That invocation, I suggest, is both unnecessary and contrary to principle. It's unnecessary because there are other ways for Rwanda to be declared or deemed safe. The Secretary of State could be entrusted with the decision, or if it is really necessary for Parliament to take it, there could at least be a power in the Secretary of State to amend it in the light of changed conditions, as was the case in Section 7(5) of the Illegal Migration Act, 2023. It's contrary to principle because it requires us to come to a judgment on a fact-specific, life-and-death matter on which we are frankly ill-equipped to adjudicate. Of course, this is not the first time such a thing has happened. It was tried in the Asylum and Immigration Act 2004, when the countries of the European Economic Area, all of course signatories to the ECHR, were deemed irrebuttably to be safe. That experiment, a requirement of European Union law, was not a successful one. Its unwieldiness was demonstrated in the case of Nasiri. The Judicial Committee of the House of Lords dismissed a challenge to the safety of Greece, but through, I believe, the noble and learned Lord Hoffman, who I am delighted to see in his place, indicated that the courts might have to issue a declaration of incompatibility in the event that the deeming provision was contradicted by the evidence.